Sherilyn Foster Tucker for Kyle Zeneli.
Kyle Zeneli. All right. What are we doing?
Your Honor, we're requesting an adjournment. I was just appointed yesterday, so we just need some time to get discovery, review it.
Adjourn to August 7th, 2024, 9 a.m.
Saturday, people address, we need corrections report. Do you have a?
I do not have a copy in the file, but yes, you may.
I apologize. I did not speak to counsel. I didn't know she was taking over for the case. If I can approach with counsel.
Yes.
The corrections report dated July 16th, I believe.
Yes.
Bench. And I know that defense counsel already has their own copy. It does address some violations of the conditions. We wanted to bring that to the court's attention.
And Your Honor, I have spoken to my client about this progress report, and Mr. Zeneli does acknowledge some difficulties complying with the sober link. We discussed the importance of being in compliance with the sober link, and he is willing, if the court is inclined, to go on a scram tether for heightened monitoring, and just to kind of make it so that he's not having to test at the specific times. And then he also has indicated to me that he does have a previous AA sponsor that he's worked with that he plans to reach out to. But he has a good job and is caring for his mom who's ill, and he has a daughter as well that he helps care for with his girlfriend. So we're just asking that this court either allows him to be on a scram tether, gives him more time to be in compliance, and get the treatment through AA.
But I have some information to share with the court when you're ready.
Yes, go ahead.
Some background on the case that may or may not be reflected in the bond form. This involved a crash. This case, investigation. He had taken his girlfriend's car and then left the scene. There was a blood draw, and that was 0.181. I would also let the court know that the defendant has a prior high BAC conviction from April 28th of 2014 in the 15th District Court. It could not be used for enhancement purposes. And the court's already aware of the community corrections report. And those are reasons that would pique our concern for the defendant remaining out at this time. He does present a danger to himself and others based on the most recent tests with the community corrections.
And Your Honor, I would just ask that he be allowed to be on a scram tether. I know that he has not been in compliance. He did, after the positive test, he did go and get an ETG test. Those results have not been made available yet. They're still pending. But he believes that he can be compliant with the scram tether, and he does have a job that he works every day, and so he's worried about losing that job. And he also, like I said, he has people that depend on him. He cares for his mom who's sick. And
so is he saying that he didn't do this? Or this is not, I mean, I thought he was saying that there was this violation of the alcohol.
He believed that the positive test may have been inaccurate, but he was unable to get the ETG test results in time. And then for the miss.
When did he do an ETG?
On July 10th.
At community corrections?
It was through an urgent care.
Urgent care?
He said his previous attorney told him to go there. It was at an urgent care. But like I said, he has not received those test results. And as for the missed tests, he does acknowledge that he missed those windows of testing.
According to this, though, he made it 6 days
6
from the time of his release, really 5 days.
before the first violation.
But he's saying these violations, I mean, I get, counsel, what you're telling me, but is he saying he drank or didn't drink?
I did not.
Because they both said two things.
I did not drink, Your Honor.
Why didn't he do the compliance test then afterwards?
That I think he was confused about.
During the time.
Well, no, he says he's confused about it. Well, before we go down that path, on the 9th at 9:01 p.m., the report indicates he blew an 028.
Mhm.
Then he blows at 9:19 p.m. He blows a .021.
Yes. And then is that when it turned off?
Mhm.
Then he indicates that the machine turned off and he thought
The what?
the machine turned off.
He knows he's supposed to do a compliance test when it comes back every 15 minutes.
Yes, Your Honor. And it's a compliance test sent, and then pushed OK, and the machine shut off at that time. That's all I know. And then I woke up the next morning and they found out that was they're blowing. And then after work, I went and got the ETG test as soon as possible. And thereon, I was talking to the previous lawyer, and she got all the emails that I had trying to track this down, but they just haven't got it back yet.
Well, then somebody's going to have to get those to me somehow or another. But at this point,
If I could just be able to continue working, and as soon as I get those results, I would personally come bring them to you or whoever I would need to. But I just would like to change.
here's the problem. What you're telling me about the testing doesn't make any sense. And about the compliance test. Because you don't do another test after the 9 p.m. test. You don't do another test until almost 12 hours later.
Well, because after the 9/17 one, when I had me reblow, is when it said compliant test sent, and I just pushed OK and the machine turned off. That's all I know. The first one did say retest, and I did that at 9/17, and it came up saying compliant test sent, and I pushed OK.
And as I indicated before, he would be willing to go on a scram tether for heightened monitoring, with the understanding that he would be constantly monitored.
Yeah. What he's telling me doesn't make sense when I'm looking at the report. Defendant's bond is revoked. Pending a hearing, they can get that to me. Defendant's remand.
What unfolded in this courtroom was a case that lays bare the tension between second chances and accountability. Kyle Zeneli stood before the judge facing serious questions about his compliance with court-ordered sobriety monitoring. The backdrop here is a drunk driving case involving a crash with his girlfriend's car and a blood draw that came back at .181, more than twice the legal limit. And this was not his first encounter with alcohol-related charges. Zeneli already carried a prior high BAC conviction from 2014. Released on bond with conditions including sober link monitoring, Zeneli managed roughly 5 days before the first violation appeared. On July 9th, he registered a .028 on his sober link at 9:01 p.m., followed by a .021 at 9:19 p.m. Then came missed testing windows. His newly appointed defense attorney argued that Zeneli believed the machine malfunctioned, that he had gone to urgent care for an independent ETG test on July 10th, and that those results were still pending. She asked the court to consider switching him to a scram tether for heightened monitoring, citing his employment, his role caring for his ill mother, and his responsibility to his young daughter. But the judge was not persuaded. The timeline did not add up. Zeneli went nearly 12 hours without completing another test after the flagged readings, and his explanation about the device shutting off did not align with how compliance testing works. When pressed on whether he actually drank, the answers from both sides pointed in conflicting directions. Ultimately, the judge revoked Zeneli's bond pending a hearing, thus making it clear that when the story does not match the evidence, the court has no choice but to act. Courts do not run on sympathy alone. They run on compliance, consistency, and truth. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.